Mr. There you are. Hello, Mr. Plafford.
Good afternoon, Your Honor.
You're up.
May it please the court, my name is Stan Plappert, and on behalf of the appellants, I would like to reserve 5 minutes for rebuttal argument time.
Sure.
As a matter of quick background, this case is about a parcel of land of over 250 acres located in Ochopee, Florida, south of Naples. Ochopee is best known for having the world's smallest post office, which, by the way, is located on the subject property. Mr. Wooten and his family owned and operated a tourist attraction on this property for many years with swamp buggies, airboat rides, and thousands of alligators. When the family sold the property, they reserved 40% of the mineral, oil, and gas rights for themselves. Appellants filed a complaint for partition in Circuit Court in Collier County on November 6, 2019, and appellee filed a motion to dismiss on November 26th. At a hearing on February 18th, 2020, the Honorable Judge Cryer ordered the case dismissed with prejudice. So we are here on an appeal of that order granting the appellee's motion to dismiss. There are basically
Let me just ask you a question as a practical matter, Mr. Plafford.
Yes, Your Honor.
I know that your prayer for relief in your complaint asked that the property be sold. Why would that have to be the remedy? It seems to me that this is that you've already, the surface estate and the subsurface estates have already been severed, at least to the extent of 40%. And it seems to me that a master could easily set out 20% of the subsurface estate area to one plaintiff and 20% to another and 60% to the defendant, and just leave it at that.
And we'd be okay with that, Your Honor. We'd be okay with the circuit court appointing a master, and whatever decision that master or commissioners decided, we would be okay with.
And so you would then be left with, for instance, your firm would be left with 20% of the oil and gas rights with no ability to extract or explore.
Well, that's a problem, Your Honor. We don't believe that the partition, we believe that the remedy of partition is so that we can enjoy what we have. In order to enjoy what we have, we would ask for a sale of the oil rights, or the commissioners to order a lease be negotiated on right, just so we could enjoy the benefits of our ownership. So that's the reason for the partition.
You could use a partition action to regain something that your predecessor in interest bargained away.
Well, they bargained away 60%, and
so they also bargained away the right to entry.
Yeah, that didn't seem to be limited to this 60%. That seemed to be the entire parcel, did it not?
It did, Your Honor, and the secondary source, which I quoted, tells us why. Because anytime the mineral rights,
whatever reason why, the words say what they say in the deed.
I agree with that. But if we look at the Texas case, which we quoted to, and I was hoping to get to, there's a bundle of rights that comes with a mineral right estate. There's 5 sticks in that bundle. And
right.
two of those sticks are solely with the surface rights owner, and 3 of the sticks are jointly held by the 2 owners. And so I believe we have enough joint tenancy that we're tenants in common in 3 of those 5 sticks that we have the right to ask the court to partition so that we may enjoy the fruits of our part of the mineral rights.
Well, I think the problem with the argument, though, is it ignores the fact that a couple of sticks were bargained away that would have, in a straight co-tenancy, would have resided in the 2 owners.
I agree. But in Florida, practically, it never happens because of title insurance considerations.
Well, whatever that the practicalities and from that perspective are, there it is in the deed.
I don't disagree, Your Honor.
The title insurance issue only arises because no title insurer wants to be on the hook for somebody who comes in and starts strip mining land that's there. So they want to make sure that exception is covered. But it doesn't change the fact that the underlying rights were traded away. So how do you partition and get back something that you've already negotiated away, or predecessor at interest has negotiated away?
Well, the appellants currently have a possessory right of 40% of those oil rights. They did negotiate the right of entry, but they still have the right of possession, and they have the right to enjoy that 40%, which they're being stopped from enjoying by the appellee.
The only rights they have to it is when they eventually have some value because they come to fruition. But your predecessor at interest traded away the ability to go in and actually remove those rights, correct?
To an extent, I agree, Your Honor. Now, the challenge is that there's a difference between the right of possession and the right of entry. And I think that sometimes that's confused. The attorney for the appellee has stated that the cases that they've quoted are cases of remainder man cases, which aren't applicable here because we have a current possessory interest, not a future one that will spring at some point. And then the cases in the brief are divorce cases in which one spouse has a possessory right until a certain point, either a certain number of years or until a child reaches a certain age, and they try to partition before that possessory right's gone. So that's not the case here.
Let me try to follow along. It's possessory in that if the party that has right to enter starts drilling, you get some of the profits. But it's not possessory doesn't mean you have the right to enter and drill yourself.
We agree. I would
currently possess essentially what is an expectancy.
We currently possess 3 of those 5 sticks in the bundle. And that Texas case, the KCM case also says that the person who possesses the majority and does have the right to entry owes a fiduciary duty to the person who has the minority, which would include liability for not renting it out, not leasing out the mineral rights.
But you didn't bring that. You didn't bring a breach of fiduciary case.
I did not, but I'm stating that gives more buttress to the fact that we have this tenants in common, which should be subject to partition.
In which case, okay, but now, say you succeeded with this partition, you would be partitioning subsurface mineral rights with no right to go on the land and explore or extract, and you would be divvying that up. What would that do to the fiduciary responsibility you contend that the surface owner has?
Well, the commissioners who would be appointed by the circuit court, I would assume, would either look at selling the mineral rights in whole or entering into leases for oil and gas, which would be the best use for both tenants. And that would take care of the fiduciary duty. And if they try to do that and there's no buyers or there's nobody who wants to lease it, then they've done their duty and there is no additional fiduciary duty. But there are oil wells all around this land. And there may be neighboring Raccoon Point is an oil well owned by the Collier family about 10 miles away that's currently operating and pumping oil. They may be pumping oil from underneath our ground. And so if that's the case, we're losing our oil because we're not drilling or we're not leasing to somebody. And so I'm just pointing out, this is not a fiduciary liability suit, but I'm pointing out that the other side has fiduciary liability. And that's one of the reasons that brings up why there is partition and why either appointing commissioners or somebody to either sell or lease the land for the benefit.
Well, I don't understand what one has to do with the other, to tell you the truth.
Well, the point of the partition statute is when there are difficulties between.
Well, because it seems to me if what you're going to do is separate out the co-tenancy, you may well be separating yourself from the fiduciary responsibility you contend that they have.
I'm not sure I understand, but if the commissioners who are appointed by the circuit court deem what's best for those mineral rights is to either sell them or lease them, then both the co-tenants would benefit equally in their percentages. So the Weed case is probably the most important case in Florida. There are 2 Texas cases, which I quoted, but the Weed versus Knox, 27 Southern 2nd 419, decided by the Florida Supreme Court in 1946, is the remainderman life estate case that was quoted in the reply brief. It states, beginning at the 3rd line of page 901, quoting, "He must have an estate in possession, one by virtue of which he's entitled to enjoy the present rents or the possession of the property as one of the co-tenants." unquote. In our case, the appellants have the right to enjoy the present rent, but the appellee refuses to enter into a rental or lease agreement. Further in this case, later in the same paragraph, it states, and I quote, the objects of partition are to avoid the inconveniences which result from a joint or common possession, to enable the petitioner to possess, enjoy, or improve his share in severalty, end quote. That's the very argument that we make for our right to partition, is that we want to be able to enjoy those current rights that we have that we're not able to because the other co-tenant refuses to do anything about them, and is basically stated in their briefs and in their motion to dismiss, they have no intention of doing anything about the oil or mineral rights.
Mr. Plappert, isn't your argument completely avoiding the obvious, which is that the surface rights and the subsurface rights always have some friction between them? Because if you start strip mining, you start putting oil rigs, you put other things on there, it affects the people, what they can do with the surface rights. And your predecessor traded away those rights and you bought a 40% interest. So now you're trying to take that 40% minority interest that doesn't have a right to say what happens on the surface or to come in and take it, and through partition come in and revive that right. Isn't that in essence what you're asking us to do?
We're not asking to revive the right, but we're asking for us to be able to receive the financial benefit from what we own. We own 40% of the mineral and oil rights, and we're not receiving any financial benefit because of the actions or non-actions of the other party. Now, this is
your view that aside from simply divvying up what's there, a master could compel one of the tenants to lease out part of the property?
I think the court could give those masters or commissioners the authority to do that.
The court, you think the court has that authority?
It says so in the partition statute, Your Honor. I'll read you the statute. Under 64.061, it talks about the appointment and removal. When a judgment of partition is made, the court shall appoint 3 suitable persons as commissioners to make the partition. They shall be selected by the court unless agreed upon by the parties. They may be removed by the court for good cause and others appointed in their places. So that's what we would like to do. And this property is basically, they take airboats and drive around it. You could put a pad for an oil well there and not interfere with the operation of the business whatsoever. It's not like a subdivision where I got a 1-acre home and I'm going to put an oil well or natural gas well in my front yard. This is an industrial piece. It's on US 41 south of Naples. There are oil wells in this area, and putting an oil well in a corner of the property would not hinder or interfere with the business in any way. I'll rest on that for now, reserve my 5 minutes, Your Honor.
Thank you, Mr. Plappert. Mr. Duncan?
Thank you. Mr. Plappert forgot to mention the fact that my client basically runs a eco tour airboat and swamp buggy business. The last thing that they want is for there to be mining or drilling on that property. And when they purchased the property, they bought it with that intention, that they didn't mind reserving a portion of the subsurface rights to the former owners, but they made it clear that it was without that right of entry for exploration, mining, or drilling.
And is your client, I don't remember this specifically, your client was the original grantee from Mr. Plappert's and his client's predecessor?
Correct.
Okay.
And we negotiated that deal, and now the successors to the Wootons, who were the sellers, want to change it. They want to try through a partition action to bootstrap in the right of entry, and they effectively contracted away that right, and they have no right under the partition action to try to bring that right back into their bundle of sticks. It's interesting that Mr. Plappert quoted Weed versus Knott, which is a Florida Supreme Court case. It's interesting where he stopped his quote, because if you read the next sentence, it says, if petitioner has no present right of entry, again, if a petitioner has no present right of entry and possession, then there are no inconveniences of joint possession of which he can complain. And that's exactly the case here. Mr. Plappert's client and Mr. Plappert have what they purchased, which is a minority interest without the right of entry, and they have no right to complain now that they should enjoy some greater bundle of rights and be able to come upon my client's property through themselves or through a master and drill or mine or search for minerals which might be below the surface. What Mr. Plappert already has is a 40% interest in the oil, gas, and mineral rights. In a partition action, the special masters can do one of two things. They can either determine and present to the court that the property is not capable of a physical partition, or they can do a physical partition. Well, in this case, because we don't know what's underground, we don't know what is there, the special masters can't really segregate out 40% of the oil, gas, and mineral rights. So the only thing that could be done was that the court could conduct a sale of 100% of the mineral rights without the right of entry, because Mr. Plappert doesn't or shouldn't be able to increase his rights by bringing the partition action. And there would be no difference between selling 100% of the oil, gas, and mineral rights without a right of entry, or the 40% that he now holds. So basically the partition action would achieve nothing. His 40% is freely sellable. He can take it out on the market. He can sell it to whomever he wants. But I think what he realizes is that without the right of entry, those rights are not very valuable. They're not very valuable until my client decides in its sole discretion whether it wants to mine or extract those minerals.
What I understand him to be asking for, and he can say this on rebuttal if it's incorrect, he actually wants to use this action to overcome that sole discretion that you have and have some third parties make the decision on what actually should be done and what entry should be made or what leases should be made. Why do you think that's offensive if your client's not doing, I mean, this is their argument, you're not doing anything to help them have any value for the 40%?
Because that was the bargain that their predecessor in interest negotiated with my client. And the court shouldn't change that contractual relationship, either through partition or some other basis.
And your client's successor or your client could ultimately decide to explore and drill and extract, or your client's successor, whenever that may be, could do that, correct? And in which case, Mr. Plappert and his other client would be entitled to their cumulative 40%.
I would agree. And for all these reasons, I think it's clear that this court should affirm the lower court's decision to dismiss Mr. Plappert's complaint. Thank you.
Okay, thank you. Mr. Plappert?
Yes, Your Honor, four quick points. The motion to dismiss standard, which this was ruled under, we believe that the lower court erred in doing it, because all we're required to do is to plead the required elements of a partition action, and we've done that. So the court here would be reviewing this de novo. The court would assume that what's within the four corners is true, and we believe that the motion to dismiss standard was
what
violated.
outside the four corners did the trial court have to rely on to determine that the relief wasn't warranted, that there was a failure to state a cause of action?
The argument was made, and what they believed was that we have a future interest. but we didn't plead that. We pled the necessary elements according to statute for partition. And all you have to do to plead partition is you're tenants in common. We are tenants in common. That's what the partition statute 64031 says. So we met in our pleading all the required elements. So was it maybe it was a motion for summary judgment standard, but they didn't properly, in our opinion, we're arguing to the court, they didn't properly meet the motion to dismiss standard.
What do you say to the argument that in essence, your 40% interest isn't going to change whether you get your partition and there's 100% and someone goes and does something? If you have no right to force them to start drilling, to enter a lease, anything like that, how is it any different for you?
Well, the partition statute, Your Honor, is like if we owned the surface rights. So if I own 40% of a piece of real estate and the two parties, me and my 60% partner, couldn't agree what to do, we partition the court. The court says that where they can't be divided, we'll order a sale. That's what they do. So I would assume that the partition of mineral rights will be treated the same way as the partition of real estate, because it's in the same statute.
But that's the whole point. You can sell your 40% now. So forcing them to sell 100% together, but there's still no requirement that there be any drilling, there be any lease, because you don't have the right to require that, absent there being some additional requirement that they go out and enter a lease, which you're then taking away the appellant's rights. So I'm just not following how you're going to get anything different except by taking away rights that you negotiated away or your successors negotiated away.
Well, Your Honor, it'd be similar to the real estate. So if I own 40%, somebody else owns 60% of a piece of land, we can't agree on what to do with it. The court appoints a commissioner and they sell it, and we divide the profits. So the commissioner would have the ability to take the full 100%, which includes the right of entry, and make the decision on what's best for that
Bingo.
property.
So that's it. You want the right of entry back in there because it increases the value of your 40% if you can use that. But you negotiated that away, or your successors, your predecessors.
The tenants in your scenario, your hypothetical, there's an impasse. There is no impasse here because you don't have any right either to enter yourself or to force the other party to enter and drill.
We have a right to 40% of the income from it, and they have a fiduciary duty to us to properly manage that for our 40%. So in that bundle of sticks, as the Texas law says, we're entitled to that rent of 40% would be normal. So I would argue that they are hindering us, and there is a dispute here over getting the value of the property, which we're entitled to.
The deed, the deed that reserved or created this split and reserved the right or conveyed the right of entry and exploration and so forth. It's attached to your complaints, correct?
Yes, Your Honor. If there are, I'll be happy to answer other questions, but that's my case.
Okay. All right. Thank you both very much. And with
Thank you.
that's the end of our docket. The way you leave is you press or click the leave button in the lower right-hand corner of your Zoom screen.